Have you heard about the free Spa Business Bootcamp happening May 31st to June 4th in the Spa Marketing Made Easy Facebook group? Each day, we're going to take a deep dive into the 4 phases of the Growth Factor framework: your sales process, your social media, your systems, and your structure, before wrapping up on the final day with how to scale. This bootcamp is a must for spa owners who are truly looking to build a company and a brand, not just create a job for themselves. Click the link in the show notes to get registered, and I can't wait to see you in the group. Hello, my dears. Daniela here, and welcome to another episode of the Spa Marketing Made Easy podcast. Now, I'm really excited for today's guest because we're going to be talking about one of the most overlooked parts of business, and that is protecting your intellectual property through trademarking. Now, imagine starting your business, working so hard to get clients in the door, finally hitting that 6-figure milestone, and then bam, one day you get a letter in the mail that says you're infringing on someone's trademark and you've got to stop using the name of your business immediately. Could you imagine the cost associated with new signage, new website, new marketing materials, all of the things? And worse yet, what if you invested thousands in packaging for your private label line only to find out that legally you cannot use it anymore? This is the risk that you're taking when you are not trademarking your business. Now, I don't want to totally freak you out because many business owners don't start this process until they have a proven concept. But in my opinion, this is one of the first things you do once you start generating consistent revenue in your company. Not when, not in that space where you're like, when I'm finally paying myself what I desire, but actually creating consistent revenue. And if you are doing a private label line, I would at least do the search on the name of your brand before you invest in any labels or packaging, because that is the last thing that you want to deal with. Now, when I first started Addo Aesthetics, we went through the trademarking process, and it took close to 3 years to go through the entire thing, be officially registered, have my trademark, all of that. But as our business grew, we saw the need to trademark our programs and even our podcast. And Keren, an attorney who was referred to me from a close friend, is who we brought in to help with the trademarking of our podcast and programs. And I'm really excited to have her as a guest today to shine some light on this topic. So let me go ahead and read you her bio, and then we'll jump right into the episode. So after working for 10 years in the corporate arena, Keren had a desire to fill the legal gap for entrepreneurs and small businesses by replacing the outdated billable hour model with flat fee pricing. With a decade of experience in corporate transactions, Keren has worked in every type of business, from side hustlers to raising millions of dollars and taking companies public. Today, she helps entrepreneurs get legally legit through her law firm, Not Your Father's Lawyer. She lives in Orange County, California with her husband and 2 children. So Keren is super easy to talk to. I loved working with her on this process, and I'm super excited to share this interview with you. So without further ado, let's go ahead and play that interview. All right, Keren, welcome to the Spa Marketing Made Easy podcast. I'm so excited to have you on. I think that trademarking, our topic of the moment, is something that's really not talked about enough. It's kind of one of those like boring topics, but it's not boring at all if you get a cease and desist letter, or if you get something that's like the risk benefit of going through trademarking and is just so huge. And so many spa owners don't even know what it is, or don't even know what they should be trademarking, or the different classes, or what the process is. So I'm so excited to have you on the show and just shine some light, shine some clarity onto this topic.
Well, thank you so much for having me. I'm excited to be here. And I agree. People think of trademark as kind of boring or unimportant, but it's a really important part of running a business.
So let's just start off by defining what a trademark is, the different classes, because I know for me in my business, I trademarked my business as one of the first things that I did, but it was a new it was kind of like a learning curve for me as we added different programs in the podcast, right? Like trademarking the podcast. So for a spa, you want to trademark your brick and mortar, but then you also, if you're developing your own private label line or, those types of things. So how do we understand, number one, what a trademark is? And number two, what the heck is supposed to be trademarked?
That's a great question. And you kind of hit the nail on the head there, which is, in short, a trademark is a set of intellectual property rights for a product or service. And it's basically to identify the origin of goods or services. So the idea is, how can a consumer or the public know who owns this product or service? And obviously you can think of it in the most obvious ways, like, I can't start a company called like Nike sneakers because I can confuse a consumer about, is this the Nike or is this not the Nike? And so the idea is to give an owner of goods and services the right to protect their brand. And you can think of trademark. There's a couple of ways that you can trademark. Obviously, a word mark is just the basic word. So the word Nike, for example, is trademarked as just the basic words, no specific font or colors or anything. But you also can trademark designs, so logos, any sort of design, icons that people might use. So there's actually two different kinds of trademarks, and you can do either or both. So sometimes when people start out, that's a big question because obviously it's two different, costs. It's two different the research to make sure that the logo isn't infringing is different than the research to make sure that the word mark isn't infringing. And what I like to tell people when they're just starting out is a lot of it depends on how you are marketing your business. So some people, or I would say a lot of people, have the actual words of their trademark brand in the logo. So if Spa Marketing Made Easy is in stylized form, obviously you have that logo and you can go out and protect that. But at the beginning, when you're just starting out and you only maybe have resources to go one way or the other, if your logo has the words in it, then if it's just a stylized version of the words, then you can trademark the word. And sometimes that's better because when you're just starting out, maybe you change your mind and you want to change the logo. And if you trademark the logo itself, you're only protecting it in that version. So if you change your logo down the road, you have to obviously trademark that. So that's something to consider as well. And you talked a little bit about the classification. So basically there are a number of different international classifications, which are basically a kind of a standardized set of classes that things fall into. And they're kind of like half products and half services. And this is one of the most important pieces of trademark law because where you trademark it and the description that you give it can fundamentally change what is and is not protected. So a great example, like you said, is you have a brick and mortar retail, space, but maybe you have a product line. Those are two completely different trademark classes. Maybe you have an e-commerce store. That's another one. And so you have to think kind of strategically about, what am I doing? Where is the protection? In a perfect world, you protect yourself across all of those categories, but small business owners often have, limited resources, and you kind of have to think through where are my biggest exposure points and go in that order of priority.
Now, when you're trademarking, you said there's international trademarks for a brick and mortar spa, there's a lot of like common names that are used, if it's just like the relaxation spa, right? Like, I don't know if anyone has that name, but if I had the relaxation spa in Washington, DC, and I had the relaxations and there was another one in Texas, would the trademark, is it per state or is it like in the entire United States, no one can use this name for a brick and mortar spa?
This is a fantastic question. So technically speaking, to register a trademark with the United States Patent and Trademark Office, to register it as used, we'll get to this a little bit, but as used in commerce, as in today it's offered in commerce, it's actually in interstate commerce. So to register a trademark federally, it has to be across state lines. So an easy way to think of that is obviously on an e-commerce site, people can, access your site from wherever. They can ship, you can ship your products to wherever. That is interstate commerce and can be subject to a federally registered trademark. However, if you have a brick and mortar in Washington, D.C., and that's all you have, and you're selling products there, but maybe not on an e-commerce site, you can't qualify for a registered trademark with the USPTO. But every state has their own state registration, and that would be a great option for things like, a brick and mortar that you're only, if you have multiple places, but they're only in state. That's a great option for people. If they're not, today, so many people have something online that they probably meet the interstate commerce rules, but that's something to think about. For example, if you have a brick and mortar space and you want to protect that name, then you might only be able to register it at the state level, whereas you could register the e-commerce site, for example, on the USPTO, which gives you the federal registration.
Now, what happens if you start your business and you're rocking and rolling, you're going into year one, you're generating 6 figures, you're super excited, and then all of a sudden you find out you didn't trademark your business and you're infringing on someone else's name?
Yes, this is a very common problem. People get excited about their business. They're focused on the important things like getting set up, finding a place to lease, getting clients, and it kind of falls on the back burner. So in a perfect world, you do some of this research up front, but it very often doesn't happen. And the worst case scenario, obviously, is getting a cease and desist. So there's kind of 2 versions that happens that I see. One, of course, is you get the scary letter from somebody's attorney that says you're infringing on our trademark. And the other is kind of right before that, where somebody says like, I just found out that there's somebody else in this space and they have the same name. What do I do? And in both cases, there's obviously the risk of infringement. So a cease and desist letter can kind of run the gamut depending on, how big the trademark owner is, how, proficient their attorney is in intellectual property law, and how big you are, because obviously the larger you are in terms of visibility and revenue, the more likely they're going to come harder on an infringement case. So a cease and desist letter can run from, hey, stop using this immediately, to not only do we want you to stop using this, we want an accounting of the last, 2 years that you've been using this mark, and we're going to seek damages for basically whatever they, whatever they can get from you. So people are a little bit more aware of this in the copyright space because, if you take like a picture from Google that's copyrighted and you put it on your website and somebody says like, take it down and you owe us $5,000, taking it down does not prevent the infringement, So when you think about it, you have to kind of ask yourself, what is the risk of doing this? And the risk is that the more likely the consumer was confused and the more likely it was on purpose, right? Like on the spectrum, the more likely you're going to end up having to pay a lot of money to resolve it. Most of the time, these infringement cases are not like that. It's not like, oh, I like that spa name and I'm going to take it and then I'm going to run with it. It tends to be more on accident. So typically a cease and desist says stop immediately. And sometimes,
which still can be costly, right? If
Absolutely.
You have to redo just thinking about signage, right? If you have to change the name of your spa, if you have to change like all your emails, your branding, your website, like that still is a pretty hefty chunk of change.
100%. And I always tell people, don't automatically assume that if you get a cease and desist that you have violated a trademark, because there are people who are more likely to go after things that are either similar or the same. A lot of people may not have a registered trademark. There's a number of reasons why, but maybe they don't have a registered trademark, but they're telling you that they're violating common law trademark, which is possible. We all own rights in our brands it's a first in time concept, but your rights are extremely limited without a registered trademark. So I always say, if you do get it, like, take a deep breath, reach out to an attorney, see what they say. Sometimes it's just kind of like a bully who's pushing a little bit beyond the reach of their registered trademark or their rights under trademark law. And that there's, you don't have to go through that whole rebranding without consulting with an attorney. But that is definitely, there's kind of the two worst case scenarios. Obviously, the worst is that you have to change everything and potentially pay to get out of it. But that tends to really be more when things are done kind of intentionally. And, but like you said, rebranding, especially, if you've ever had to pay for a sign on a building, they're several $1,000s. So that alone, plus again, redoing the website and the loss of your brand, that
the goodwill that you've built up with that name recognition.
Absolutely. Yeah. So something that I tell people, because sometimes people freak out like, oh my gosh, I didn't do this. What if I am? What do I do? Even if you did it at the beginning, or if you didn't, I always say, like, put it on your calendar once a quarter, do a Google search, like, see what's out there with your name or similar names, see what's out there, on social media. And number one, that's important for yourself to protect your own brand, obviously, but also it helps you kind of see what's out there and what other people are using in the industry to make sure that there isn't a problem. Because it's if you got here to today and there is, and sometimes this happens, by the way, that somebody says, oh my gosh, I did what you said. I went and searched, and it turns out there's like, a competitor of mine out of, some other state that has 150,000 followers on Instagram, and I'm just little old me. But then we go and we run a trademark search, and it's like, well, to be honest, you've been using this mark longer. They don't have a registered trademark. Let's file the trademark. And then we get to send them a cease and desist, And so there are a lot of ways to kind of look at it and strategize, even if you didn't do it at the beginning.
Okay, so let's just clarify a little bit the difference between, for your state trademark, the federal trademark, if you're a brick and mortar spa versus having the product line versus having the e-com store, because there's so many different variations. If you are the relaxation spa and you just have a section on your website that is where to purchase products, that could essentially be an extension of your current business. But what I'm seeing a lot of spa owners do, especially with 2020 and all of the COVID and all the things, they're starting their own skincare lines, which are essentially completely different businesses.
Exactly.
So they would have to run a full separate trademark, likely in a different classification.
Right. So, definitely in a different classification. So let's say you already have a trademark for your, brick and mortar store, even if that's on the state level. So I'll kind of touch on that at the beginning, right? Is that anything that's in interstate commerce can and should be registered on the federal level. And you don't need to do a state level and a federal level trademark. There might be some strategic reasons, but rarely. If you can register at the federal level, that's usually what you're doing. If you want to do, a skincare line at the federal level, but you have this one brick and mortar in your state, that is probably going to be a state specific trademark, because again, the actual spa services that are being provided only within state lines are not going to be subject to interstate commerce trademarks under the federal protection. So you can have a trademark with the same name, relaxation spa. Let's say you get that, within the state of Maryland or whatever, and then you have the skincare line. Now you're going to register that with the USPTO, and it's going to be a completely different class. So when you register a trademark, there's two ways you can register it. Is with already used in commerce, which is kind of what we're talking about, right? It's being sold in interstate commerce. The second piece is with an intent to use. And the thing about an intent to use is that trademark laws, people can't just squat on trademarks, right? So you can file an intent to use application. So if you think you have this great idea and it's a competitive market and you don't want somebody else to steal it, but you haven't launched yet, you can file it and get the process going while you're kind of doing this. And then once you get the approval, then you basically have 6 months with some extensions to actually prove to the USPTO that you use it in commerce. Otherwise, it goes away and it's abandoned and you don't have the right to the trademark. So if you file, if you're setting up a vertical in your business and and let's say I guess this is all to say, let's say you are like, well, I don't have a trademark right now. I want to do it for my e-commerce site, but I'm also working on the skincare line. So maybe I want to do 2. You can file 1 trademark where some of the classifications are used in commerce and some are intent to use. And it basically kind of goes through this process where they'll approve the part, that's you kind of go through to get to the registration on the used in commerce. And then you have to kind of catch up with the intent to use stuff, but at least everything's kind of there. Like I said, it's a first in time concept. So obviously if you kind of wait on the registration because you haven't launched it yet, but somebody beats you to the punch in terms of filing registration with the USPTO, it puts you in this position to like prove otherwise, which is effectively litigation. So it becomes costly and then most people don't do it.
So logistically, how long does filing a trademark typically? I know it's like a big question, but
a really long time.
A really long time. How long does it take? How much does it cost? Like, what's the range of these types of things?
Sure. So a trademark that doesn't have any issues whatsoever goes like this. You file the application. Well, your attorney or the platform you use or whatever you do does the research to confirm that it's likely to be trademarkable. Basically, that means number 1, that there's no conflict or no major conflict or a conflict that's not kind of strong enough that you still want to pursue. Number 2, that it's actually registrable. One of the things about it, and I kind of joke because we were talking about relaxation spa, which is there's like a spectrum of registrability with the trademark office. And basically the more arbitrary or fanciful, which are the technical words, but the more arbitrary would be like Apple, right? You think of before Apple computers, nobody associated the word Apple with technology. So it's arbitrary, but it's a real word. It's just arbitrarily associated with that brand, that industry. Obviously, fanciful is something totally made up. And then it goes down the spectrum from, to things that are a little bit more descriptive. If it's descriptive, there's supposed to be some kind of mental leap that people have to make. And then generic would be like, I can't trademark business law firm. That's just generic. There's nothing to it. Descriptive could be more like relaxation spa, right? Like, it's pretty descriptive. It's almost generic. It's questionable about whether that could be registrable. So that whole process has to be done up front. Then the second piece, obviously, is you file the application and then it just sits there. And typically an application that has no issues is 6 months. And even now, just I think with COVID and, the examining attorneys are working from home and everything's, I've never seen in 12 years it take this long, but sometimes it takes 6 months even to be like assigned to an examining attorney. So 6 months to a year, longer if you have, if somebody files an opposition, if the USPTO has an issue that you have to respond to. So the process is you file the application, it gets assigned to an examining attorney, they'll run their own search. If they don't have any conflicts with it, they will schedule it for publication in the official Gazette, which is basically it's published in a searchable medium for 30 days so that if somebody out there wants to oppose it, they would file an opposition, say like, we oppose this registration, because the USPTO isn't like going out on Google and looking out what's out there. They're only looking what's registered with the USPTO. But obviously other people might have rights that they want to oppose, but it's their job to go out and pursue that. Then if no opposition gets filed, you wait and wait and wait, but eventually you get that notice of registration. And that's when you get the, R with the circle symbol and you have your registered trademark. In between that, what happens a lot is that the USPTO submits an office action, which is basically, it could be anything from this isn't registrable because there's a conflict to we don't like the specimen you provided, or we want you to disclaim this word. So there's a lot of little or big issues that can come up. in the process. Obviously, if they think that it's too similar to an existing trademark, then you are typically an attorney, because it requires case law and research, that they respond and say, here is all the reasons, the factual and kind of case precedent reasons why we don't agree, and you kind of try to overcome that. And that's kind of the process.
But you do get to hold your spot in line, so to say.
Correct. Right? Correct. And that's why we go back to that first in time concept, which is, even if you file, sometimes it takes people 3 years to get a mark, or 5 years, because of whatever process they go through. But at the end of the day, they started it, if they started it in 2015 and they don't get it till 2021, it's still theirs. And anybody in the process that had tried to, come up with something similar will still have, that person will have superior rights to those later uses.
Okay. So what advice, just in kind of wrapping this up, what advice would you give to someone if they're looking for an attorney like you do trademarking? We'll share your information below, but what are they looking for in an attorney? What questions are they asking? What's important when trying to choose an attorney or a company to do trademarking with?
That's a great question. I personally believe, and this is not just trademarking, this is any legal work, is that you should really feel comfortable with your attorney. I think, people have their kind of, it's like the caricature of an attorney. They're kind of like mean and grumpy, and they talk condescendingly to people. And I always say, I have like the legal knowledge, but you are the business owner. You're the expert in your business. So I'm not going to tell you what to do. I need you to tell me what you do. And I'm just going to fill in the legal part, And I think that that's really important, to have somebody who's willing to listen to you, to understand your business. And when it comes to trademarking, that's especially important, because like we said, the classifications really matter, and you want to make sure that you're covering yourself in the most kind of robust way, so that you're protected in all of the verticals that you offer, and that you have, the protections that you're seeking when you apply. The second piece to that, obviously, is somebody who's familiar with trademark. And, it's a complex area of law, and a lot of business attorneys do trademark and other intellectual property work, but some don't. So it's important to understand, do they file trademarks? Do they file them in your industry? Have they worked with people in your industry before? So that they really understand kind of what they're getting, and making sure that they have somebody that understands the industry and the business. And then I think the other piece to that, which is kind of ancillary but really important, is there are a lot of platforms out there like the Legal Zooms, and there's some kind of cheap trademarking platforms that really are quite a bit more cost effective. And I get the question a lot, like, what do you get with a lawyer versus this? And the short answer is, you don't get a lawyer when you work with those. They're algorithmically based. And if you have simple and straightforward trademarks, they're often a really good option. There's two problems to that, right? One is, you don't know if you're going to get the right protection, and you don't have the benefit of going back and forth and talking to somebody, to make sure that everything's properly described, because the classifications, there are kind of like pre-approved ones, but you can also write your own if yours doesn't really fit exactly into those. And so there's a lot of different pieces. And then the second piece is, what about if you get an office action? Is that extra money, or do you have to go now find a lawyer to do that, and all of that piece? So I think understanding kind of what you get in terms of cost, and how they're going to guide you through the whole process, and not just filing the application, but, do they respond to the office actions? Is that additional cost, or is it included in whatever fee you pay? Are they going to take you through the whole process? And that's an important thing to consider.
I don't think we answered that question of what is the range of price.
Oh, so fees themselves, the actual USPTO filing fee is $250 per class. And it can go up I said we could make these custom ones, and the custom costs a little bit more because, and they're also much harder to get approved. So if you want to fit into like the pre-approved bubbles, but if you don't, then you definitely want to work with a trademark attorney who's familiar with it, so that they can write you kind of a custom description that's going to get approved. So it's $250 to like $350 per class. So again, if you have the brick and mortar, and then you have the, and I guess that's different with state, but if you have a retail stores plus a skincare line plus an e-commerce store plus a clothing line, right? Whatever that might be, 4 different classes. So if you're filing 4 different classes, it's times the 250. So that's just the filing fee itself. In terms of the attorneys, it can range. I mean, the platforms can range from a couple $100. A big intellectual property firm is going to charge tens of thousands of dollars. A smaller firm is going to be more like in the, maybe as low as $1,000, as high as $5,000 range. But it really runs the gamut. I could probably find you a $500 attorney and a $50,000 attorney for the same work,
Yeah, I know. It's hard with legal, but it's one of those things, like, I'm such a rule follower. I'm like, I just want to make sure that it's done right, that my taxes are paid. So for me, it's like having that protection is just so important, because I don't even want to think about someone sending me a letter. Like, there's enough that we're doing to grow our business and serve our clients, but that's the last thing you want to be thinking about.
Yes. And, people have different levels of risk tolerance. And so I think some people operate, obviously I'm a lawyer, so I'm risk averse by nature. So I'm also a rule follower. And, but I work with a lot of people who have different levels of risk tolerance. And some people say, I'll kind of see what's out there myself in an informal way and hope for the best. And some people say, no way, this is one of the first things I want to invest in for my business. I always tell people, the more proprietary your brand is, obviously, when you think about like a skincare line and e-commerce, that it really is easy for people to kind of get in your space, versus like a brick and mortar is going to be a little bit harder for somebody to like show up across the street with the same or similar name, it's a little bit easier to be aware of that in the community. But online, it's a big wide open space, and it's a little bit of the Wild West still. And so, that protection as you grow a brand, and like you said, right, the cost of, changing a sign we think it's expensive to change a sign on a brick and mortar building, but to change like your packaging on 100,000 units of of inventory is significantly more expensive. So
it could put you out of business.
100%. So a little bit is that kind of that risk tolerance that you have. Obviously, it's one thing to have 5,000 units of inventory and trying something out and kind of seeing what sticks. Maybe that won't be as costly as, and a website might be not as costly. Maybe you don't have your own skincare line and you only sell third-party sites, and a website rebranding isn't necessarily as costly from a financial standpoint. It can, like we spoke about in the kind of the goodwill space, be pretty costly to the brand and the business.
Very good. Well, share where our listeners can find you, follow you, get in touch with you.
Yes, you can follow. My website is notyourfatherslawyer.com, and you can find me on Instagram mostly at notyourfatherslawyer. And, happy to talk to people, but there's a lot of free resources out there, myself and from others, that, to make sure that people are getting the information that they need in terms of, starting and running their businesses.
Super, super helpful. Keren, thank you so much. We'll include the links below this episode so you can stay in touch with Keren. You can learn about trademarking, decide if that's something that you want to do in your business. And if you have questions, be sure to head on over to the Spa Marketing Made Easy Facebook group, and we'll catch you on the next episode.